පටන් ගන්නලාට කියන්න මම. Good evening and welcome to today's class about business law. Actually, when we consider the term business, it has several areas and sections. Like we know, in a business environment, there could be various components, such as the more commercial component of doing business, as well as the business entities that are engaged and dealing with the business activities. So today we are going to discuss in this business law chapter on the second type of area that I mentioned. It's about the institutional side more than of the business side. What I really mean in the context of law, we call it as company law, or what the law relates and apply to companies and corporates. So with that introduction, I would like to talk to you today about the contents of today's lecture that I would be dealing with. Generally, the introduction of the subject that I would like to take you all through, and then the nature of personality, a natural person and a body corporate in these institutions that I mentioned, and about the similarities and differences between personalities involved in these various types of associations, organizations, corporate sector. And then about the very landmark case of Solomon versus Solomon and Company. You might have heard of this in other classes as well, but let me take you through the more legal aspects relating to that case. And then about the history of company law, the characteristics of a company, then how to incorporate and what means by incorporation of a company, then rights and liabilities of the shareholders, the real actors of a company, then again touching upon another landmark case, the Ashbury Railway Carriage and Iron Company versus Ritchie. Then about the directors and their qualifications, because directors are the ones who control the operation management of a company, and about their disqualifications. So, in order to start today's lecture, I would like to first introduce this subject to you all, and in doing so, let me first explain to you the importance of commercial activities and the law. The law is as old as any trade that has taken place in this world. With the emergence of different trade activities, or rather commercial activities, there were laws that came into being. May not be first of all as written law, but what we tend to call as a common law, which means that the laws developed by the adjudicators of a certain dispute. Now, if I take you through to the history of this area of the law, whenever there was a dispute relating to a commercial activity or a trade activity, then the adjudicators, or those who decided what should be the outcome and what are the remedies that could be afforded in this dispute, the adjudicators themselves listen to such conflicts and disputes and decided what the best alternative it could have, or the best remedy that could be applied to solve a dispute. So, disputes arise actually as far back as the history can ever see, where a commercial activity really started. Because there was so much of concerns of what could be the type of engagement in this business, or what are the rights and liabilities of the parties who are involved in this commercial activity, and so forth and so forth. So, the law developed likewise parallelly in the way and mode I mentioned, that maybe in the times of the ancient monarchs, that the kings and the queens set up their own adjudication systems within their kingdom and kept some prominent people of a certain caliber. They may not have been lawyers or those who really profess a profession of law, but who could hear the matter, especially hearing both sides in a dispute, and then take a decision which is quite independent and not being biased to a side, in order to find the best remedy for the problem at hand. So, in doing so, they come up with a certain judgment that would apply to this dispute, and then whenever there are disputes arise, these adjudicators came up with various types of awards and judgments and decisions and likewise, that later developed into a kind of a set of judgments and decisions that became a part of the jurisprudence in the subject of law. So, that gave that particular country or the kingdom set of rules that were developed by these adjudicators in disputes to move ahead and set up a legal system. So, likewise, these decisions have helped develop a legal system quite a lot, and it was at a very later stage that rather written laws or the laws passed by the legislatures or the parliaments came into being. So, in the world, if we go on searching for the history of the law, it always could be found in the words of the rulers, words of the kings, or words of those experts who attended to the dispute resolution process. In this way, the law developed to the present status that we are living, or are the state of what the law is right now. So, therefore, the commercial law was also developed likewise in parallelly with other laws as well. But now we do have much developed set of laws that could be domestic, that could be international in application. So, the commercial law developed in such a way that, first of all, it gave the application to the domestic legal system, especially to formulate the laws applying in this commercial sector, and thereafter it developed into an international setup with business activities taking place internationally. And for that we know new set of international rules were built to cope up with the development of the trade and commercial activities in the world. So, what I would like to emphasize in this first point is that the law is an important and integral part of the entire field of commerce. And these laws regulated the entire commercial world. Now, we do have laws that apply domestically in countries as well as internationally when the commercial activities take place in a cross-border situation, or where the business activity takes place from a country to a country. What we generally call in common terms export-import trade. So, in this entire trade, the existence and emergence of company law plays a huge role, because in every country we could see these companies existing in various formats. There are mainly two types of legal systems when it comes to company law. One type is what we call the legal systems that recognize the incorporation of a company. The other set of countries, or rather legal systems, is what we call the countries that require not the incorporation of a company, but having the real seat of that company in a particular state. So, the commercial world was regulated in such a way and also brought into being the controls and statutory enforcement on how to keep this area going or working smoothly, so that there won't be any conflicts, there won't be any differences, there won't be any contradictions in the application of the law. Now, controls and statutory enforcements are extremely important because of the fact that the laws are meant to have controls and enforcements in these commercial setups, and these controls and enforcements could either be due to the development of the common law, or what we call the development of the case law, the decisions of the judges, or the enforcements and controls initiated by statutory means, or what we call the laws produced by the parliament of the country. As we know that the laws developed and enforced by the parliament in a country like Sri Lanka are considered to be highest than anything else. If we take our legal system, the most supreme law in this country is the constitution of the country, and all other laws stand lower than that or under this particular umbrella of the constitution. Company law is one of these laws that stand under this umbrella of the constitution in facilitating the enforcement, control, and all the other areas of matters that pertains to companies and the corporate sector, since we are today dealing with corporate law or the company law under the business law sector. Now, I mentioned to you commercial activities started way back in the history. I don't think that anybody could really tell when did these business relationships started in the world. So it goes back to time immemorial. But however, relationships that were built up between the business partners became quite important in the world. Now we may see such companies that exist right from history, maybe during the last 500 years. In Sri Lanka, we do have companies that have existence of more than 100, 150, 200 years. If we take some branded names of companies that exist even today. So, the relationship of forming these commercial activities became the roots of what we are presently dealing with in corporate sector. And as I mentioned to you, the domestic and international relationships build up from time to time with the emergence and the flowing of the commercial world, commercial relationships, doing business with other countries, and now we have come to a stage that globalized business activities play a huge role in our own day-to-day life. Sometimes even we may not be able to live without these companies' existence, either domestically or internationally, and therefore it is important for us to learn about company law or the law relating to the corporate sector as a part of the business law studies. Now, due to the fact that the domestic law of a certain country could conflict with another domestic law of another country, international law has emerged as a matter of unifying and harmonize the various business activities that are being conducted internationally between citizens or inhabitants of one country and another. And you are quite conversant with, I know, that in international business environment, there is no way that one country's law can be taken out and applied in that particular business relationship. You need to have a unified, harmonized system of international law that would apply to these different players from different countries. Therefore, harmonization is very important. The area of company law is no strange to this. Now take an example like this, where a Sri Lankan company doing business with another person or a company abroad. In order to do business in that particular country, they might require that the Sri Lankan company is properly constituted under the law, so that that particular foreign country could recognize it in this entire business process. That is why we need the recognition of international companies as well as the law that harmonizes the entire business process. Coupled with that, it is also necessary to have a proper dispute resolution system attached. Now we know in Sri Lanka we have a very good judiciary system running from a magistrate's court, then to the district court, then to the high court, to the appeal court, and to the apex court called the Supreme Court. Likewise, also in other countries, there are different sets of courts being constituted in accordance with their judiciary needs. When there is a dispute that occurs domestically, the domestic courts have the competence, or what we call the jurisdiction, to deal with such matter. When there is a conflict that occurs internationally, there also shall be competent courts with the jurisdiction to deal with such matters. And what we have heard of, for example, the International Court of Justice that deals with the cases in between states, then international arbitration tribunals or international arbitration courts that try private conflicts or disputes between private individuals of different companies or different countries. So therefore, the dispute resolution system is a very important element in domestic level as well as international level. And nowadays, as I mentioned previously, whenever an exporter or importer or two foreign nationals from two different countries get together in a business agreement, the primary thing that they discuss is where should we have the dispute resolution at times of a dispute. Whether it's an international arbitration, whether it's an international negotiation, whether it is an international conciliation, or whatever, that they agree upon one particular forum as a matter of choice of jurisdiction. So choice of law, choice of jurisdiction are two important areas to deal with. Now I gave this introduction to you in order to have a clear understanding of the areas that we are going to discuss from now onwards relating to our subject matter. Let us now get into more of the essence of the subject by discussing the nature of personalities among ourselves, among various players in the commercial world that would be legally acceptable. Now, legally acceptable is a very important matter because, as I mentioned to you, if there is any conflict, if there is any dispute, it's going to end up in a court. And what the court would do is that it would apply the law of the state or the law that is applicable internationally. What the law would see first of all is what we call the status quo. The status quo or the legal character of this party that is coming before the court, and also the legal status of the party that is being made responsible in this dispute. In order to solve that, we need to identify the various types of personalities that are accepted by the law. So let's start with a very simple word, a person. Who is a person? Now, a person could be like us, a human being. Human being. Human being is a biological person, built with blood, flesh, veins, and these kinds. And he or she is recognized by the law as an existing natural person. Also, the term person is referred to anything that has been created by a statute or by the law. Statute is legislation. So, anything created by that legislation that is existing to be termed as a person. So, these natural and any person created by a statute can include natural or what we call the juridical in nature. Juridical in the sense a certain person created by the law is called a juridical person. We are biologically made people, persons, as I mentioned to you before. But now if you take the Chartered Accountants, Institute of Chartered Accountants, Sri Lanka, this is an institution that has been created by a statute in the Parliament of Sri Lanka. Also as a person who conducts these lectures, a person who gives you the qualifications to become an accountant by profession, right? A person who confers degrees, diplomas, postgraduate, whatever. A person who regulates the conduct of students as well as their staff. So, it is this institution that has been created as a juridical person in nature, existing also, extending also to associations like a club or like a society, associations, or partnerships where several people come together and form a kind of association which can be termed a partnership. And corporations, the more formally created institutions that are also called companies. Then organizations such as movements, could be social, could be political, could be business organizations. Then legal representatives, whoever who represent a certain person legally. Now it could be that I personally give someone the power to represent me in case I am not in a position to represent by myself. Now, take an example such as when I go abroad. If I go abroad, I give my power of attorney to somebody that I trust and know, so that in my absence in this country, that particular person can execute matters by representing me on behalf of me. So, that particular representative also has a certain adapted personality recognized by the law, as well as the states, the countries do have a personality that is recognized as a country by the rest of the countries in the world, as also by international organizations, starting from the UN to the specialized organizations and to other, and the countries, of course. So, there is no big difference between a state and a country, but however, there are in federal states, there could be small states within one country. Example, India, United States, and so forth. Now, I would like to raise the question, what is the difference between a natural person and a juridical person? Now, I myself or you yourself are natural persons. You are a biological. You all are made of flesh, blood, veins, and so forth. We are all biological people. But however, the fact that I told you these chartered accountants of Sri Lanka is a creation by statute and termed as a person is not like us. This institution does not have blood, flesh and veins like we have. It is not a biological person, but it is a person created by the law, recognized by the country where it is being created. So, therefore, the juridical person is a person created by the law, and that is why I have given that answer in such a way for you to easily understand the difference between a natural person and a juridical person. So, what is an association? Because association is the one that really starts an organization or a company or any other movement consisting of natural people like us. Association, as the word very linguistically defined, is a collection, any group of people who have joined together for a particular purpose. So, why have they joined together? They have joined together for a particular purpose, that is to do or not to do something, to act in a way or not to act or omit that way. So, it is for this purpose that this group of people have joined together. And in the commercial field, this could be the purpose being a commercial purpose, or in a non-commercial environment, it could be for a non-commercial purpose. Now, look at a family union. A man marrying a wife, or a man marrying a woman is a union which is also an association. Is it commercial? No, it is social. Then when they have children, they have a group of persons in that family where they have the children and have a family for a non-commercial purpose. It's a more social purpose, for which that they have formed this union, the family as an association. So, association term can extend to a huge spectrum, and also where this purpose brings along an objective or several objectives. So, this association has been formed for a purpose that consists of either one objective or several objectives to be executed by this group of people in this association. But also legally to be recognized, this particular association has to be legally established. And also it could be that the particular organization, the particular association has been formed as an organization, partnership, or as a company. Now we are going one by one further, and that we would have a much bigger analysis on what really this association would turn out to be in our subject. Now, the next important question would be how to start this association, or how does any association or alliance is formed. Now, it could be formed either by way of statutory provisions, that means the law, the legislation, or by registration alone, consisting of a group of persons, as I mentioned, or that particular association becomes a company or companies that have a common objective or objectives as a means of original formation or merging. Which means that an association could be formed with all those purposes, objectives and everything what I mentioned, legally creating it through a kind of a constitution, so that the members or the group of people understand for what they have really formed this company or the association, and what are the rules and regulations that they are bound by. Since the constitution covers most of the important areas that governs this particular association. If it's a private kind of association, it could be formed by their own constitution. If it's going to be a statutorily created body, it should be formed by way of a statute or an act of parliament, like the Chartered Accountants of Sri Lanka. Or if it's a commercial company, then form under the relevant applicable company law in the country. If it's a partnership, and a formal forming of a partnership, there can be a partnership agreement between the parties, that they come together as partners and abide by the partnership agreement and its terms and conditions contained therein. So now I would like to take you further to the topic of a body corporate. which is a much higher step than a normal association or a partnership, but has more legal bearing on its existence as well as the functionaries that this company is going to execute. According to the very famous Lord Lindley in United Kingdom in the past, he held in the House of Lords in United Kingdom that an association of many persons who contribute money worth to a common stock or employed it in some trade or business, and thereafter these people in that association share the profit or the loss arising therefrom, has a much bigger bearing of being a corporate entity. Now, these body corporate may be of public in nature, it could be a private company, it could be a public-private partnership, and also it could be an onshore company or an offshore company. So, whatever it is, there can exist of various types of body corporates. Now, I would like to explain to you more on what really means by a corporate entity further, but before I go there, since I mentioned the fact that a particular corporate body could be of these categories, what are they? Being public. Public in the sense it is more of a state owned nature, or that particular organization or body corporate could be a purely private, which means that it has been commenced by or started by some private individuals without any involvement of the state, the country. Or it could also be a public-private initiative where certain sector of public organizations or certain sector of private people getting together and forming these companies. Now, public-private initiatives have been in the news in Sri Lanka in the recent past, because the government of Sri Lanka is quite keen in sharing its business activities, commercial activities with the private sector, and then call for a public-private initiative. Now, look at Sri Lankan Airlines. Sri Lankan Airlines was previously called Air Lanka, completely held by the government. So, it was a public company. And thereafter, certain part of the company was sold, or rather offered to any private party interested in getting into a joint venture with the government. In that case, it was once offered to Emirates, that Emirates took over with the government stakeholding intact and ran for some years until the government retook the Sri Lankan Airlines, and presently even running as a public company. But again we are hearing news that the government wants to enter into a public-private initiative in carrying on with the Sri Lankan Airlines business activities, because they would like to, the government would like to entertain private investments in this joint exercise as a public-private initiative. And also there may be corporate bodies that are created on land, on shore, as well as out of this country. Some public corporations do have their subsidiaries or their parts in other countries. So likewise, you can also have offshore companies as well. Let us now discuss about the similarities and differences between personalities. The personalities who are engaged in these types of associations. Now let us look at the difference between a natural person and an association. Now I told you previously that a person being an individual of biological means he has an identity. What is our main identity? We have a name. Then we have some sort of a document that could recognize us. The birth certificate. It could be the identity card. It could be the passport. An association is a group of persons, as I mentioned. And this particular association may also have a name and also some other means of recognition, such as a certificate of incorporation, a certificate of registration, like a business registration document, or even mixture of all these things. And an association can be not only group of persons, but also it could be persons and also companies in that. Now if you look at some companies in this country, we have natural persons holding shares. Sometimes you may say Mr. X holding 45% of shares, Mr. Y holding 10% of shares, and ABC company holding another 45% of shares. So likewise, a company or association can also mean that it's a mixture of natural persons as well as some other corporate bodies. The similarity there is that association consists of natural persons, but not always. It could also be a mixture of natural as well as juridical persons, as I showed you before. But a natural person is always a natural person. It's a biological person. So therefore, associations tend to take more of a juridical personality than of a natural person. So, what I would like to emphasize in that first section is that a natural person is legally recognized in the same natural context, whereas an association that they form could be a juridical person consisting of these people, but recognized by the law as one person, the association. But it is always not the same case, especially when there is a partnership. Now, partnership and a company or a partnership and association have two different meanings, even though a partnership could be an association. Association consists of two or more people that we know. It needs at least two people engage in a social or business enterprise having common objective. And these people who are in the association are called co-owners, especially in this business activity. And in a business activity, when you form an association, likewise, it turns out to be a partnership. If the particular association has been created for non-commercial activity, such as, for example, a social service organization, that social service organization is an association without any commercial objectives, but where the natural persons who are inside the association form part of this association as a whole. What happens in a partnership is that a partnership is more of attaining a common objective. I do not say that there can be a social partnership. Of course, there can be a social partnership. In a social partnership, the objectives are more of non-commercial means. And that sort of a partnership is not meant to do business. But the partnership that meant to do business is more of a commercially sound or commercially viable in existence, consisting of the partners in that association. And we call them co-owners again, or the partners in the partnership. Then what is the difference between a partnership and a corporate body? In law, the partnership consists of the co-owners who are natural persons, where the partnership has no existence if these natural persons leave the organization. The partnership is there because these partners are existing. In case one partner dies or leaves, the entire partnership collapses. Because the partnership has been formed with a common objective of all these partners to attain a certain goal. So, in case one partner leaves or disappears or dies, the entire partnership collapses because that common objective is lost. And also the fact that in a partnership, all these partners are individually responsible to the partnership, individually liable for this partnership, whatever happens, and also they are entitled to share the profit of the partnership on an individual basis. So the partnership may term that whatever the profit would depend on the investment factor of the partners and on the investment ratio that the partners have invested on this partnership, and the profits will go to each and every one in the manner stipulated in their partnership or agreed between the partners. And the tax component for each of these partners are personal to each of them and have to be paid by each of them personally. Now, the difference between a partnership and a corporate body is that a corporate body is a much strong and formal organization created under the corporate law of the state, where even though there are partners or the co-owners, what we call the shareholders in a company, exit the particular company, the company still exists. So the exit of a shareholder in a company does not mean that the company would collapse. The company would stay. Because a corporate body, though it is created by these natural persons, it is a formal legal body that has its own distinct personality as a person. That particular characteristic is not there in a partnership, as I mentioned to you before. So a corporate body has a much bigger character than a partnership, that it has a distinct personality, or rather a separate personality than that of its creators or the shareholders. And a company exists even without these shareholders. This is what we call the existence of a juridical person, which cannot be alienated by the absence of a certain person or persons in that particular company. The company remains as it is in law, even without the presence of the natural persons inside that company, the shareholders. So therefore, the existence of the company always remains until it is being dissolved. It is that the law that has to dissolve the company in the ways that it is mentioned in the company law of that country, or otherwise the company would exist. So that is the difference between a natural person and a juridical person. A natural person doesn't exist anymore after his death, but a juridical person will exist until it is been legally dissolved. Now take the example of a king in a country, a king or a queen is a state head. Even if a king or a queen dies, there is no end to the position of that king or the queen. That's why we say sometimes the king is dead, and then we say long live the king. Now if the king is dead, how can the king live long? That is because the position or the office of the king doesn't disappear with the death of a natural person who is holding the position of the king. It is same thing with regard to the Pope in Vatican. When the Pope is dead, the Vatican announced the Pope is dead. At the same time, it says, long live the Pope, because there is a natural person who would replace that dead person in the position of the Pope. The same scenario with a king or a queen. So that is why they say, long live the king, or long live the queen, or long live the Pope. That shows that a juridical person created by the law doesn't disappear unless it is terminated or dissolved in accordance with the law. Same strategy applies to companies. Companies exist until they have been dissolved. So the death of a shareholder, a disappearance of a shareholder from the company does not make a company die. Company will not have a natural death. Company will only have a judicially defined death. You need to go for a dissolution of the company in order to put an end to the company. So within that context, if you look at the corporate versus shareholders versus directors, corporate is one juridical person under which or within which the shareholders exist. The shareholders exist as the creators of this corporate company, and also there are a set of people who are working as directors of the company in the board of the company, board of directors, and these natural people can have an entry and exit from the company, to and from the company, without having any kind of disturbance to the personality, the juridical personality of the company. That's why we say a company or a corporate is a distinct entity from its shareholders. Who are the creators? Why the directors are agents of the company appointed by the shareholders, and they are liable only in event of their personal wrongdoing. Because for any entitlement or liability, it is the company that assert such entitlement of liability, entitlement or liability, and not the shareholders or the directors of the company. The company can stand on its own. Likewise, a company can sue in its own name, and company can be sued in its own name. That is because a corporate or a company as an entity have this distinct personality recognized by the law. To be a juridical person having existence until it is been dissolved in accordance with the law that it was created. Now, I would like to address on the corporate personality in particular and how the company law applies. In doing so, let me first of all tell you what is a company in law. What is a company in law? We know now, having gone through the previous discussion, that a company is an association. Yes. Or it's a collection of individuals. Yes. These individuals are the ones who created this company. Yes. And these individuals could be natural persons or legal persons, such as another company that creates a company. Like a company creating a subsidiary within its, having holding company and subsidiaries, or mixture of both. Sometimes you may find a certain company creates another subsidiary, giving certain number of shares of that new company to some individuals, as well as retaining some of the shares of that new company with the mother company. There are classic examples if you look at the corporate world. So therefore, company acquires characteristic nature of being a legal person, that the law recognizes a company as a person before the law. Even though we may only see it in paper, we may see it physically that there is a building in the company, the law gives much higher recognition by making a company a legal person. Legal person that has the right to sue and be sued, likewise a natural human being. So, if you leave a natural person aside, we can call a company an artificial person. Artificial person created by the law. But in legal context, we call it a juridical person. Now, I raise a question thereafter, is it same as its shareholders? Is the company same as its shareholders? No. I have given you the answer before, and we are now revisiting this. A company is a distinct person operating separately from its shareholders. Even though these natural people are the ones who created this company, the company now has a distinct and separate existence. And the law recognized it to have the power to represent itself before the law. Then I raise a question, can a company sue and be sued in its name? Yes, as I mentioned before, and we are revisiting again, being a legally recognized person before the law, it can sue and be sued in its own name. No need to take the name of a natural person, a shareholder. No, the company's name. The company can sue as well as be sued without taking use of the names of the shareholders or the directors of the company. So, if you happen to sue a company, you don't really have to take the heck of looking for the names of the shareholders or names of the share directors. You straight away sue the company in its corporate title, ABC Company Limited. The incorporation under the law of the state in which it is registered enables it to be identified as a person who is legally created and termed as a judicial person. Now let us look at a landmark case in the area of company law, which is like the heart as well as the head, because the company law really can be said to have originated with this particular case that happened in England, as well as it operates as the heart or the main vein in the entire spectrum of company law. And that is the case of Solomon versus Solomon and Company. Right? Now, what happened in this case? Mr. Aaron Solomon started a leather shoe production business, and that later became very lucrative business for him. It was very successful. He expanded the business, but what he did was, with his expansion, he created a company called Solomon and Company Limited. He put an investment capital of 39,000 pounds, and he took 20,001 shares and bestowed 6 other shares among his family members, who became shareholders by virtue of obtaining those 6 shares. In the meantime, Solomon, investing the capital, made 10,000 pounds as a means of a debenture or a loan, what we call a secured loan in the company. Unlike an ordinary loan from a creditor that we take, a secured loan have a much bearing on the company assets. Having taken that debenture, he ran this company, but soon the company was not doing business well, and it went into bankruptcy. It lost the business, and finally it came to a situation where the assets of the company only valued for 7,773 pounds. Then, the debt was 7,773 pounds, but the worth of the assets were only 1,050 pounds, 55 pounds. So, if you look at the remaining assets of the company and the debt that the company owned to private unsecured debtors, it is not sufficient to pay off these unsecured debtors from the available assets of the company. But bear in mind that on top of that, Solomon also has 10,000 pounds of worth, 10,000 pounds worth of debentures issued to him as secured loan. And then Solomon said, now his creditors, to whom the company was at debt, filed a case for winding up, closing up of this company, Solomon and Company Limited. Then in the court, the biggest question was, how could we give the 1,055 pound worth assets setting off against these unsecured creditors of the company who have given the loans, where the company is at debt. At the same time, Solomon mentioned to the court that he should be settled with this £1,055 because he has the secured loan debenture for 10,000. Then the creditors said Solomon should not be paid because this is Solomon's company. So why should Solomon be paid for anything? Because this is Solomon's company and we are outsiders. We have given loans to this company. The company owes debt to us. So we should be paid out of this money. Then the court ran into various legal complications in solving this matter. But however, it was held by the court that having considered the Solomon's status as a secured debenture holder, right, secured loan for which the debentures have been issued, the secured loan stands higher than unsecured loans. Therefore, the secured loans have to be paid first. So what qualified was the Solomon's debentures of £10,000, which he couldn't recover, but he could at least recover 1,055 worth assets that were remaining. But the argument that Solomon is same in this company, it is Solomon's company, was rejected by the court, stating that in a situation of an incorporated entity, whoever the shareholders could be outside of the company's personality. Company is one, shareholders are other. So therefore, the company, though started by Solomon and the company are two different persons. And therefore, Solomon, by being an debenture, Solomon being a secured loan person who has given the secured loan as debentures, was entitled to the only remaining assets of £1,055. So that made it a landmark case where in company law, company personality is different from any other shareholders or directors' personalities in that company, and the company has a distinct personality even distinct from its own creators. Now, with that introduction on the company structures, let me take you to the history of company law. Generally, or the general history of the company law was that it derived from the word corporation, or the Latin term of corpus, the body, corporate, that consists of a body of persons and dates back to the reign of Justinian, where the Roman law recognized a range of corporate entities under the names of universitas, corpus, collegium, and so forth. One famous example of a later development of the structures of companies was the East Indies Company of the Dutch. Now we know that in the history, Sri Lanka became a colony of the Dutch. But the Dutch controlled Sri Lanka by way of a company called East Indies Company. it's very famous, or what we have learned as VOC. VOC. This is one of the very classical modern companies that existed. So this East Indies Company had these colonies in the east, and they were trading between the east and the west through this company. In the medieval period also, the government, local authorities were created companies such as the Pope, as I mentioned, the City of London Corporation, a statutory body, and companies that came from the charter of the king, such as the Stora Kopparberg in Sweden. Now, if you look at the Sri Lankan history of a company, the Sri Lankan company law does not go to that much of a classical period. Actually, the commercial activities were quite regulated in Sri Lanka during the English time, when we were under the rule of the British. Therefore, this derived from the law in United Kingdom that was introduced around 1837 through Chartered Companies Act. There are companies formed under a seal. Where company is formed under a seal. So the most important element in this our company law history is that a company to have a seal as a main requirement, and that even exists till now, that the seal of the company is so precious. What we also sometimes call, not the rubber seal, the corporate seal, which is made of iron, and it embosses the paper. So, first law was Joint Stock Companies Act in Sri Lanka 1844, where liability was made unlimited for shareholders. Further developed through the Building Societies Act 1874, 1894, 1939. But however, the more modern and our own post-independent company law came into being with the adoption of the Companies Ordinance in 1948, which is a consolidated legislation of all those pre-existed laws that I mentioned before. And in fact, the recent one was the Companies Act number 17 of 1982, which was replaced by the new one, the Companies Act number 7 of 2007. So the present law applicable to companies in Sri Lanka is this Act number 7 of 2007. And all what you need to know about company law is mentioned here in this Act. This new law is a follower or a creator based on the models of Canada and New Zealand in their versions of the company law. Now, under that particular company law existing in Sri Lanka, let me explain to you what are the characteristics of a company, what are the types of companies that are accepted legally in our country. The first type of a company is called company limited by shares. What is this? According to section 3, subsection 1, resubsection A, a company that issues shares, the holder of which have the liability to contribute to the assets of the company, if any, specified in the company's article as attaching to those shares, which means that a limited liability company can be set up in Sri Lanka by investing the money for either a share or number of shares, and the liability or the responsibility towards the company of that particular investor, of that particular shareholder, is only with regard to the one or the number of shares that he has taken up. Now, for example, say I would like to invest in a company with 1000 rupees, and this particular company share value, single share value is 10 rupees, and I am entitled to buy 1000 divided by 10 shares, which is 100 shares. And I take these 100 shares, and I know that this company is a limited liability company where if this company runs into a bankruptcy situation, if this company experiences losses and close down, my liability as a shareholder to this company is only for that 100 shares which I bought at 1000 rupees, which I pay back that 1000 rupees as my liability. I am no more liable than that. That is what it states, that the company is limited by shares. Such a style of a name of such a company could be ABC Limited, which is obviously a public company because there is no word private there. So, ABC Limited means the shareholders have limited liability in the company. Or it could be a private company, which is ABC Private Limited. Yet again, the shareholders have only the liability towards the number of shares that they hold. So, like in that Solomon versus Solomon and Company case, if a particular company has run into a bankruptcy with a huge amount of losses, these shareholders will not be asked to pay all those losses. They are only liable towards their committed number of shares because this is a limited liability company. Limited liability. The second category of companies recognized in our law are called unlimited liability company. Now, this is exactly the other side of a limited liability company, where the shareholders, by virtue of holding shares in that company, becomes unlimitedly liable. So, in a case of a bankruptcy where the company has incurred millions of losses, the shareholders have to pay and settle that million of losses because their liability is unlimited in this case. And therefore, unlimited liability companies such as ABC Unlimited or ABC Private Unlimited companies are there in existence. But however, due to the fact that the liability would be unlimited in such a situation, the creators of companies do not go into creation of these unlimited companies that much generally, because the liability is so huge and We do not know what it could be. And even a normal person can run into entire bankruptcy because of this company's failure in securing the expected goals. The third category of a company that is recognized in our law is called the company limited by guarantee. This means where the shareholders give a guarantee that at a time of a company bankruptcy situation, the shareholders would pay the debt and they guarantee for that action. So that is why it says that it is a company guaranteed, where the shareholders give a guarantee that in such a case the shareholders would contribute towards the entire liability of the company. So these are generally the three types of companies recognized in our law, and the first category, the companies limited by shares, are the most commonest out of all. But there are also several guarantee companies that exist. That is generally in a case where a certain social services organization would like to go into commercial activity. Sometimes we have seen this in Sarvodaya movement, that they create certain commercial company, but out of whose money? Out of the donors' money. So in a case that such a company goes into bankruptcy, it is not fair on the donors who have contributed towards this social organization to see that their money is gone. So in such a case, they create a company by guarantee, where the creators, the shareholders, knowing that this is coming from a donor agency or donors, they give a guarantee, okay, we do the business, if we fail in this company, if this company runs into bankruptcy, we will pay the losses. So that's the nature of a guarantee company. The next I would like to talk about is incorporation. How do you incorporate a company in Sri Lanka? What are the necessary steps of setting up a company, first of all? For that, Section 5 of the Companies Act, number 7 of 2007, deals with the more basic elements required for the formation of the company. It says a duly filled application in the prescribed form, the form 1 that is provided by the Registrar of Companies in Sri Lanka, where you could go to the Registrar of Companies, obtain the form 1, where you fill up the details that is required, and then you attach the other company documents, whatever needed by the registrar, and hand over to the registrar, who will thereafter go through all these things. If everything is in order, he issues and enter these particulars in the company register and assign a unique number such as P within brackets a number, or PV and then within brackets a number likewise, and then issue a certificate of incorporation. Now this certificate of incorporation is the most important document in a company. You might have seen in some companies they even frame that and put it on a wall in the company, so that you can show that it's a incorporated company. Also the fact that whenever you've been sued, when the company is sued or the company is suing somebody, you need to show to the court that you have the legal personality to appear before the court by virtue of holding this incorporation, certificate of incorporation. What are the prerequisites that you need to tender along with your application for the obtaining of a certificate of incorporation? First of all, you must have articles of association. Articles of association. In the past, under the former law, I mentioned to you number 17 of 1982, there was a requirement to submit not only the articles of association, but also a memorandum of association, which described the objects and the functions, the powers of the company and so forth, the basic document. But now under the new law of Act number 7 of 2007, you don't need a memorandum of association, but you only need articles of association. Now articles of associations is like a constitution of the company. It specifies the objects, the purposes for which the company has been created, the rights and liabilities of the shareholders, the shareholding, and then the directors, appointment of directors, how the directors could be removed, how the company could be dissolved, what sort of resolutions that have to be obtained, how to convene the annual general meeting, how to convene the extraordinary general meeting, how the finances should be maintained, who are the auditors, all sorts of things are mentioned in these articles of association. It's like the constitution of an organization. And also, the next important one is that you must give a name to this company. First of all, you have to fill a name. Now, there is a requirement under the Register of Companies that prior to requesting the certificate of registration or certificate of incorporation of the company, you need to check with the company registrar whether there is a name that is similar or equivalent to what you are going to register, which is already registered. Now, say for example, if the intended company name is called Rajakiya, whatever, sometimes there may be another company registered with the same name Rajakiya. Then in that case, the registrar will not approve your name. So you need to do a name checking, first of all, with the registrar. But if you say the former company is called Rajakiya Ayurveda Samagama, and what you want to create is Rajakiya Aushadalaya, which are quite similar, right? The company registrar will have a very careful reading of these two names and compare whether there would be any misleading, of course, misleading of the fact. Because when you say Rajakiya Ayurveda Samagama, Rajakiya Aushadalaya, it both relates to some kind of a pharmaceutical or medical business. If the registrar is of the opinion that registering the second name would have conflict with the first name, then he might refuse to register the second name. But if you want to register Rajakiya Jatyantara Pasala, is not an issue, because these two names differ by content, by name. So, in that case, the registrar would allow. So, always when you register a name, you need to see first of all whether there is an existing name or whether there would be conflict with this existing name, and you must avoid those things and bring in your new name of the company. But however, the law doesn't permit you to use certain given terms in the law, in the act, such as you cannot have a name such as Chamber of Commerce in first place, but you can have the name Chamber of Commerce subject to the fact that the particular industry ministry approves your name. Now, there are certain chambers: Chamber of Commerce for shipping, Chamber of Commerce for trade, Chamber of Commerce for small and medium enterprises. Now, those are different areas. If you want to register a certain chamber, it is possible to have Chamber of Commerce Pharmaceuticals, but however, you need to get the permission of the subject minister of that ministry. If it is pharmaceutical, then it is health minister, for example, in order to use the name Chamber of Commerce. Otherwise, it is not possible. Also, you cannot use the term president or presidential in a company. Also, you cannot use the word municipal, because these are reserved for certain officers in the state. You cannot also term incorporated. You can't say incorporated ABC Limited. Incorporated term is not given. Cooperative or society. National, you can't use the word national in your company name. State, Sri Lanka, you cannot use. But many companies prefer to have the names like Sri Lanka, because it gives a certain image, or it carries a certain image. In that case, we have seen, rather than using the term Sri Lanka, they use the name Ceylon, Ceylon tea, which is quite possible because it is not in the prohibited list of names. Also, some people, when they can't use national, they use the term nation, nation trust, which is possible because it is not national, and nations is not a prohibited term here. So, the essence is that prior to any registration or incorporation, you need to see whether the name has no issue. So, let me explain to you in an incorporate or in an intended incorporation of a company, who could be termed as shareholders of a company. Shareholders of a company. Shareholders consist of persons entered as shareholders in the register of shareholders holding at least one share, whose name is entered as shareholder in application for registration of the company, who is entitled to be entered in the share registry in an amalgamated company, when you amalgamate a company. Person to whom a share has been transferred and awaiting entry or ought to be entered in the share registry. Then beneficiary of a trust for whom a share is held prior to entering such trust in share registry, and to whom a share has been transferred but has been wrongfully omitted from the share registry. So all these categories of people, persons, are entitled to be shareholders of a company. But you may see that here there is no age barrier mentioned. But however, it is the common law situation that in order to become a director, you need to attain the age of 18, but it is no barrier that a minor could hold a share. Now what happens if a person dies and he bestow or bequeath the shares that he has in a company in his child name? Generally, you appoint a custodian for that child, and then the custodian looks after the share until the child becomes 18 years. Let us see the rights and liabilities of shareholders. Rights and powers of a shareholder, what are they? The shareholder status cannot be altered unless by special resolution. When a person is mentioned as a shareholder, his status as a shareholder cannot be omitted unless by special resolution passed by shareholders meeting. And even then, if that particular shareholder is not happy or satisfied, he can still go to courts against that. Then the shareholder has the right to vote at all company meetings of the shareholders, annual general meetings, extraordinary general meetings. A shareholder can also alter the company's articles, I mean in a shareholders meeting or annual general meeting or extra general meeting, ordinary meeting. A shareholder can also approve a major transaction, because shareholders are the real owners of the company. Even though the company is a distinct person, we know that without the shareholders, the company can't run. Company can exist, but the company can't do business by itself. You need the shareholders and the directors appointed by the shareholders to run the company. So the shareholders always have the power to approve a major transaction that a company is doing. Approve an amalgamation of the company, amalgamate. Reduce the company's stated capital. Resolve the voluntary winding up of the company. Change the name of the company. Change the status of the company. Status in the sense from one business area to another business area. Change it. Require the company to purchase minority shares, minority buyout. Take action against oppression or mismanagement, including injunctions. I would be dealing with this area later on. And also on the derivative actions that the shareholders can bring in. Then the rights and liabilities of shareholders. What are the liabilities of a shareholder? Primary liability depends on the type of company against the held share, whether the liability is limited, whether the liability is unlimited or whether the liability is guaranteed, under guarantee. Also, a pure private act in terms of contract, a pure private act of a shareholder would mean that he breaches the contract law, he breached the tort law, he breached the fiduciary duty or what is in trust or other actionable wrong. And in such a case, we apply the rule of piercing the corporate veil, which I would explain to you all in a later discussion in this series of lectures. Also, the shareholder is liable to pay for the share in respect of a call, where the share has not been settled by the shareholder, but when the company requests the shareholder to pay for the share, then he is liable to pay that. He has not yet paid, but when there is a call to pay, he is liable to pay. Call to pay the share value. Also, the shareholder being exonerated from liability in case of any act or default or obligation of the company. What the company has done wrong, the shareholder is not liable unless the shareholder was involved in that wrongdoing. Then we lift the corporate veil to see who is inside and then put the liability responsibility upon the shareholder. That I would be discussing later on. Then alteration of articles of association. If the articles have been altered, then in that case the shareholder will not become liable for that, because it is the company that finally takes that decision in the annual general meeting. Requiring to hold or acquire more shares. If in a minority buyout, if a certain shares have been passed to a shareholder, so he is holding the shares of the company for which he may not be liable. He should be exonerated. And then former holders of shares on call when call is made. Whereas a particular shareholder has sold his shares to another person and he is no more a shareholder. So, if the company calls the former shareholder to pay for the shares, he is not liable. So, he is exonerated from such liability. So, today we end up at that point, and tomorrow we will be discussing more on this related subject. Thank you very much for listening, and we will see each other tomorrow at the same time.